Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, I will acknowledge that I'm a little late to the party. This ruling came out yesterday, but I spent most of today, now it's evening out here on the West Coast, running around playing lawyer, so just now getting to sit down and record this video. But as you know, we got a huge ruling out of the 10th Circuit yesterday. A huge ruling as it relates to statutory waiting periods. You know, we will let you exercise your right, but only after we make you wait and we get to pick when you actually get to exercise that right. Well, it appears that New Mexico's statutory waiting period has been struck down. I'm sure Governor Lujan Grisham is completely crapping herself. But listen, this has huge potential, and it has huge implications for people in other states. Colorado, you better be listening. So today, let's spend a few minutes, let's go through the court's order, and let's talk about the 10th Circuit strikes down waiting periods. Okay, America, big ruling out of the 10th Circuit involving New Mexico's statutory waiting periods. Colorado, you also sit inside the 10th Circuit and have a similar challenge going on inside your state right now. So heads up, this is a very positive development. Back in 2024, Governor Lujan Grisham, when she wasn't just sua sponte taking people's concealed carry rights, pressed the New Mexico State Legislature to pass a 7-day statutory waiting period, which means that even when your background check cleared, and even though you may have a concealed carry license and this may be the 35th firearm that you've ever purchased with absolutely no criminal history whatsoever, the state of New Mexico figured they knew better and they were going to make you wait 7 days. This, of course, led to a challenge, which is a now successful challenge. The case we're talking about today is Ortega v. Lujan Grisham. It comes out of the 10th Circuit 3-judge panel. Now, this case was originally obviously litigated at a lower trial court level, who for some reason found no problem with this statute whatsoever. And I want you to pay attention to how they justified it, because this shows the dangers, not only of statutory waiting periods, but it shows the dangers in what happens when a court just has complete and utter disdain for lawful, responsible gun owners. After an evidentiary hearing, the district court denied preliminary relief on 3 grounds. First, it found the right to keep and bear arms did not cover the right to acquire arms. That is perhaps one of the most dangerous rulings we can get. Imagine that type of logic being used in states like California. What would prevent you then from banning gun stores altogether? The district court got it wrong on a couple of other grounds as well. Second, it found that the waiting period was a presumptively constitutional commercial condition on firearm sales carved out by the Supreme Court in District of Columbia v. Heller. Because waiting periods have existed for almost a century and their burdens are supposedly minimal, plaintiffs did not overcome the presumption. Third, the court ruled in the alternative that the waiting period fit within the principles underlying our historical tradition of regulating firearms. Now, this argument that, well, the Second Amendment only protects the right to keep and bear arms, it says nothing and provides no protection whatsoever to the right to accumulate firearms, is in fact one of the most offensive and dangerous and candidly one of the most stupid arguments we could ever see. Of course, that didn't stop the state of New Mexico from using it, hasn't stopped the state of California from using it multiple occasions. The 3-judge panel here, though, correctly addressed it as follows. Common sense dictates that the right to bear arms requires a right to acquire arms, just as the right to free press necessarily includes the right to acquire a printing press, or the right to freely practice religion necessarily rests on the right to acquire sacred text. Legal interpretation follows that common sense. When a text authorizes a certain act, it implicitly authorizes whatever is a necessary predicate of that act. And despite the fact that we have a litany of cases such as Teixeira that says that the Second Amendment also protects all ancillary rights necessary to the exercise of the core right, apparently the district court in New Mexico did not get that memo. As a paper or computer is a necessary predicate to the right to print, or the ability to own property is a necessary predicate of the right to just compensation for a taking, acquiring, purchasing, and possessing firearms is a necessary predicate to keeping and bearing them. And if you sat there and you read New Mexico's response brief to this, which was absolutely ludicrous, they basically said that, hey, listen, maybe a waiting period could infringe upon rights, possibly, but not here. And their circular argument was as stupid as it was illogical. That led a 10th Circuit panel to rule, so by New Mexico's illogic, a restriction on firearm sales does not burden the Second Amendment until it does. The court spent more time shredding apart this incredibly intellectually dishonest and dangerous argument as follows. New Mexico's argument that limitation on firearm sales or transfers do not implicate the Second Amendment's plain text is wrong, and the district court's engagement in limited means and scrutiny is also wrong. The district court's analysis, crediting what it saw as a minimal burden, circumvented Heller, Bruin, and Rahimi, landing right back at the freestanding interest-balancing approach that those cases explicitly rejected. Listen, anytime a court starts using language like, well, it may burden, but it's not a significant burden, we are right back into the balancing tests that Bruin rid the courts of. But we see these balancing tests being injected all over the place, like in common use for self-defense. That's a balancing test. More appropriate for military use. That's a balancing test. And here we actually saw a complete and actual articulation of a balancing test, which is, yeah, it may have burdened the right, but we don't believe it burdened the right enough. Now, there is a litany of case law out there that says the Second Amendment is not a second-class right. Unfortunately, throughout the country, it is treated exactly as though it is the red-headed stepchild of the Bill of Rights. The three-judge panel here, and I think this is an argument that we should do more frequently, is let's take all of our other rights and put them in the same bag as what we've done with Second Amendment rights and ask yourself, does any of this make sense? Take, for example, what the court said here. The burden imposed by a cooling off period is brought into sharper focus when considered in the context of other constitutional rights. A carte blanche 1 week cooling off period to publish news stories? Unconstitutional. Temporary closure of churches during COVID-19? Unconstitutional. If a criminal defendant had to wait 30 days after his arraignment before he could seek legal counsel so that he would not unduly resist his prosecution, unconstitutional, of course. The Second Amendment is no different. The constitutional right to bear arms is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. An absolute fantastic statement. But you see, the state of New Mexico, they know what's best because they realize that, well, most people who are probably going out to try to buy firearms are up to no good, or at least that's how they believe it. Unfortunately for New Mexico, the 10th Circuit was not persuaded. In short, regardless of the paternalistic intent, waiting periods burden the right to keep and bear arms. Now, the state of New Mexico tried to argue that, hey, listen, this is just a condition which we can place upon the commercial sale. The court said, no, this is not a condition like passing a background check or paying the required fee. This is an intentional delay, hindrance, and obstruction of what is supposed to be an inalienable right. And that has led them to rule as follows. But a cooling off period is not such a condition or qualification. Plaintiffs argue that it is not a condition because it cannot be met by any action, and it is not a qualification because it is universally applicable. They are right. A 7-day waiting period is not a condition on a sale any more than the price of a firearm is. The sale happens regardless, and the waiting period is just an artificial delay on possession. And here's the thing. While New Mexico may have wanted to claim that this was just a condition on commercial sales, this actually goes well beyond commercial sales. Private transfers, for example, also subject to a 7-day waiting period, leading the 10th Circuit to rule, it is not enough that a regulation sometimes affects a commercial sale. A blanket waiting period is simply not of a kind with the conditions and qualifications imposed by other presumptively lawful measures. Now, with the court finding that this clearly did place a burden on Second Amendment rights, it is the government's responsibility at that point to justify it through historical analogs. And clearly, the state of New Mexico was incapable of doing this. Now, the state of New Mexico in their briefing had actually kind of said, why are we getting so caught up on history? They literally spent time saying, history, schmistery. We need to do things our way. The 10th Circuit was not at all impressed with that argument and pointed out, this is why we have to remain moored to history when it comes to Second Amendment analysis. Why do we require those showings? Through them, we seek to honor the fact that the Second Amendment codified a pre-existing right belonging to the American people, one that carries the same scope today that it was understood to have when the people adopted it. Now, going back through history, you can imagine all the creative stuff that the state of New Mexico used to try to justify that, including some very, very racist gun laws. However, what they really tried to hang their hat on is this is necessary to make sure that guns are not falling into the hands of the wrong people, which, by the way, a federal background check does exactly that. And in most instances, including the two named plaintiffs in this case, they passed that background check almost immediately, yet still had to wait an additional 7 days. Why? Because the state of New Mexico apparently knew better. The court went on to rule, but those early examples are easily distinguished from this one because they were explicitly tied to the time it took to conduct a background check. Until the 1990s, no waiting period law required a prospective buyer to wait longer than was necessary to conduct a background check. Well, and if we're looking for historical analogs going all the way back to the ratification of the Second Amendment, then the 1990s is a little late in the ballgame to be using that as proper historical justification, even under a Rahimi's relevantly similar, more nuanced approach. Given the few states in which they have persisted and their duration, waiting period laws cannot satisfy the government's burden. You see, the state of New Mexico, like many of the other states here on the Dirty Dozen list, are of the absolute belief that anybody who has the audacity to want to own a firearm is actually up to no good, that they are a ticking time bomb, that they are a criminal just waiting to happen. And it is this disdain for the exercise of constitutional rights that motivates attorneys like me to stay engaged in this battle. The court was not persuaded by it either when they ruled, but the only way the Waiting Period Act fits into that principle is if anyone seeking to purchase a firearm can be presumed irresponsible or non-law abiding purely by dint of their intention to purchase a firearm. Constitutionally, they cannot. We similarly reject New Mexico's attempt to declare the entire population of New Mexico presumptively dangerous to themselves or others only because they want to acquire a firearm. Now, again, we're not going to spend any time on New Mexico's response brief to this, but it is quite comical. And yes, this three-judge panel had a field day tearing the argument apart, including statements such as, this principle cannot clarify the Second Amendment's scope because the principle itself contradicts the Second Amendment's existence. No meaningful limitation could be placed on the government's power to regulate firearms, disarm the citizenry, or criminalize firearm use if we accepted every regulation that is based on a fear that someone somewhere would likely misuse a gun. And that is the exact position that the state of New Mexico and many other states on this list right here take on a daily basis, that any person who is desiring to possess a firearm, their true intent is to commit criminal activities or act in an irresponsible fashion. Fortunately, for the citizens of New Mexico, a three-judge panel of the 10th Circuit was not persuaded because they have ruled. For these reasons, we reverse and remand to the district court with instructions to enter injunctive relief consistent with this opinion. So, New Mexico, for the time being, your 7-day waiting period has been struck down. I am sure that your governor and attorney general have crapped their pants and are already working on an appeal to a full en banc panel of the 10th Circuit. Colorado, you have a case that is similarly situated, kicking around as well. And this bodes very, very well for the arguments against Colorado's statutory waiting period again. Okay, the case once again is Ortega v. Lujan Grisham. We'll link it up down below so that you can geek out on the opinion for yourself. You don't have to take our word for it. Now listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.